Welcome, I'm attorney Alma Rosa Nieto, and I have great news today. The Supreme Court rendered an important decision, a historical decision on June 26, abolishing Section 3 of DOMA, the Defense of Marriage Act. This will now grant federal benefits to couples that are married of the same sex. They will grant benefits in the Social Security arena, in health care, and most importantly, from my perspective, because I'm an immigration attorney, immigration benefits. Now, always, whether you are a couple of the same sex or a heterosexual couple, you must show to immigration that you entered the marriage for love and affection and not solely to get a green card. That is still the law. The same requirements will apply to both couples. However, I've discovered that there are three groups that will benefit from this. One is those that entered into the United States without documents and are now living here and are married or in a relationship with a same-sex couple. Or those that have entered into the United States legally, and maybe years ago, and now their documents are expired, but they are in the United States and they entered into the United States with some proof from the embassy or some legal form into the United States. And lastly, those that are abroad, they live in their home country, they've never entered the United States, but they have a long-distance relationship with a United States citizen. First, the group that is the largest are, of course, those that have entered into the United States without documents and are now living into the United States. If they marry in the United States, in one of the states that recognizes marriage of the same sex, or they marry abroad in their home country and the marriage is recognized in their country, the United States citizen will now be able to get a green card to their partner. Now, this process will have to be consular. That means that the couple will have to go and travel to their home country to get a green card and an interview with the American embassy. And if they've lived here for some amount of years out of status or illegally, they will need a waiver called an I-601. The second group are those that have entered the United States legally but somehow have lapsed. They're out of status now. If they marry in the United States, in a state that has recognized the validity of a same-sex couple marriage, then they will be able to adjust their status and immigrate within the United States. The process is roughly between 4 to 8 months, depending on the district, but the whole process will be done within the United States without having to go abroad to the American embassy. And lastly, there are people that are in relationships long distance. So the U.S. citizen lives here and their partner is abroad. If they marry in their home country, the United States citizen will now be able to request a fiancé visa for that person in their home country. They enter into the United States on a K visa, fiancé, and then within the United States they adjust their status and get a green card. Or the U.S. citizen can go abroad, marry the person that is in their home country, and petition for the green card process all in the embassy. So there's several choices. I must add that stepchildren, maybe the partner in their home country or here has had a heterosexual relationship before and has children that were born abroad as well. The United States citizen will be able to immigrate their partner of the same sex and their partner's children, their stepchildren, if the marriage entered before the child turned 18, and the child is under 21 and single. So great news from the Supreme Court. This is a monumental decision, in my opinion. It's changing history. And please, please do share this video with friends and family so that they know that DOMA Section 3 has been abolished and the new procedures to get a green card for partners of the same sex. Thank you for watching. My name is Alma Rosa Nieto, immigration attorney. Until next time.